Senator Patrick Leahy, during the confirmation hearings of Judge John Roberts at the time, he's going to become the Chief Justice of the United States Supreme Court. Senator Leahy said, Judge Roberts, this is the only time we have a chance to look at your judicial philosophy. Go back and check that out on C-SPAN and look at the John Roberts hearings. So basically, this is what happens when it comes to judges. All right, they decide based upon the bedrock view or living document view. Bedrock view is an originalist view. The living document view says that, hey, you know what? The Constitution changes with time, i.e., we end slavery, right? We end segregation, women have greater rights, et cetera, et cetera, et cetera. So basically, a judge makes their decision based upon what their judicial philosophy is. Are they moderate? Are they liberal? Are they conservative? What channels do they watch? All right, CNN, MSNBC, Fox News, the Progressive Channel. All those make a difference in terms of judges. And so, should we expand the Supreme Court is a question, right? In other words, make it equal. Make it equal because President Obama gets a chance to put anyone on the Supreme Court. These are issues that are out there today.
One of the most maddening and, to my mind, stupidest news cycles during the presidential campaign was the great court packing controversy. Will Joe Biden endorse expanding the Supreme Court to add more justices? The reason it was so dumb is that it was completely a science fiction question dependent on a whole bunch of things happening together, like flipping the Senate first and then also ending the filibuster. And we still don't know if those things will happen. Most likely they won't, even though we can't get those 2 weeks or so of our lives back. And yet there is a substantive issue about the legacy of this right-wing Supreme Court, the lower courts that have been packed by Donald Trump and Mitch McConnell. And that's why there is an urgent and concrete argument for Democrats now to think about how to restructure the judiciary. Somewhat radicalized over this issue is Brian Fallon, longtime Democratic operative, Hillary Clinton's former press secretary, now perhaps singularly focused on making the courts more progressive. He's the co-founder and executive director of Demand Justice, an organization that is devoted to doing just that. Brian, first lay out for me, I guess, like the kind of blue sky. Do we have you? You hearing me?
Yes, I can hear you.
Oh, great. Lay out for me, just like let's get rid of institutional constraints or any sort of constraints. If you had a magic wand, right? Like, what would a plan for restructuring the judiciary or expanding it look like if you could do whatever you wanted to do?
Well, I think you'd want to do two things, Chris. I think you'd want to first expand the size of the court by no fewer than 4 seats in order to undo the injustice that was done with the last 2 vacancies, or at least 2 out of the last 3. You had unprecedented maneuvers by the Republicans to block any consideration of Barack Obama's nominee in 2016. That was unprecedented. And then just this year, you had another unprecedented move in terms of confirming a justice, rushing to do so right before an election, confirming somebody closer to an election than has ever happened before in the nation's history. And now Republicans say, hey, that's fair game. That's within the rules. That's not unconstitutional, to which I say fine, but neither is expanding the size of the Supreme Court. That's happened 7 times in our history. During the 1860s, it happened 3 times in that decade alone, during a period where the nation was undergoing a big political shift. We were entertaining big questions of what it means to be a citizen, what is entailed by the right to vote, not unlike the debates we're having now. And so I think that people need to be imaginative, open themselves up to this possibility. Adding to this size of the Supreme Court will restore balance. 6-3, the margin that we have in the court now, it's something that when you poll average people, they do think that sounds out of whack. So we're starting to see support for this. This is pushing majority level support with the public. The other thing I would add, Chris, is term limits. I think you can do both in combination. We should bring a sense of regularity to when these vacancies arise on the Supreme Court. If you get elected as president to a 4-year term, you should have some certainty that you're going to be able to appoint at least 2 justices in that 4-year window. Jimmy Carter won 1 term for president, didn't get to name anybody to the Supreme Court. Donald Trump won a similar 4-year term, and he picked 3 justices. And that's how we end up with randomness of, Democrats winning the popular vote in 7 out of the last 8 elections, and yet Republicans picking 15 out of the last 19 Supreme Court justices. So I put everybody on an 18-year fixed term so that seats are expiring every 2 years, and expand the overall number to 13.
That latter point is such an important and good one. There is nothing like it in American politics, the macabre death watch for Supreme Court justices. I mean, it's sick and bizarre. it's like buzzards circling overhead. There's just nothing like it. It's a lifetime appointment, obviously. Justices can choose when they retire, but if they don't, as we saw with Ruth Bader Ginsburg, who battled against various illnesses with incredible fortitude for so long, that's the situation you end up with, just the spin of fate's wheel. You're saying get rid of that, have some regularity to it. I think it's a good idea.
If you added to the number of seats on the court and in combination to that added fixed terms, the death or the retirement, the timing of a retirement would be less of a stop the presses triggering of an all-out war, because each individual seat is less high stakes if you have more than 9 seats. And if there's some rules set in so that every president is fixed in terms of the number that they can appoint in any 4-year window, then it prevents the incentive for Mitch McConnell to try to keep a seat open to create an extra seat for the next president to fill. Right. It would restore sanity to the process. It would truly depoliticize things. And people, there's bipartisan support for this. Nobody less than John Roberts himself, when he was a Reagan administration lawyer in the 1980s, penned a memo for the Reagan administration suggesting that there should be term limits for Supreme Court justices. So this is an idea that has appeal. Term limits has 70% support with the public. I think there's going to be a more robust conversation here, not least because the Biden administration is committed to appointing a court reform commission in 2021 that I think is going to look at both of these proposals and then some. And so I think it's very important that that commission include voices like Eric Holder, Heather McGhee, the former head of Demos, Professor Michael Claremont at Harvard. These are all people that have been out there making the case for particular reforms, and I think would be valuable voices on that commission.
Yeah, and my understanding is there's some conservatives, I believe Stephen Calabrese, who is a law professor and one of the co-founders of the Federal Society, has written about term limits as well. I mean, the idea of regularizing, I didn't say that right, but we'll keep moving, of these terms such that everyone has a kind of democratic transparency going into election. I mean, that's part of what's so crazy, right? You then know, okay, well, we're voting for a person who's going to appoint X many seats, as opposed to a veil of ignorance and, depending on the luck. And there's no conservative or liberal valence to that question. That's just a question about us as democratic citizens knowing what we're getting.
Right. And I think that we should also approach this with the goal in mind of trying to undo vestiges of our system that lend themselves to minority rule. Yeah. The Supreme Court, as it's set up now, is really the outcome. The 6-3 majority that we have on the court now is really the outcome of sort of 2 counter-majoritarian factors that have compounded into this 6-3 court, which is woefully out of step with the public on everything from healthcare to gun safety to climate change. And that's because you have in Donald Trump somebody that lost the popular vote by almost 3 million votes, who made 3 selections to the Supreme Court that were confirmed by Senate Republican majorities that represent less than a majority of the public in the country. And I think that all these proposals go together. The idea of rethinking the Electoral College, eliminating the filibuster in the Senate and adding states so that we increase the size of that chamber, and reforming the Supreme Court.
Democracy is the North Star here, Brian Fallon. Thanks so much for making time tonight. That is all in for this week. The Rachael Maddow Show starts right now. Good evening, Rachael.
Chris Hayes, your show tonight and your show last night were as good as any TV shows you have ever done. You are doing such good, no, seriously, you are doing such good work right now, and I'm learning a lot from your I'm learning more from your hour every night on TV than I'm learning from anybody else in TV news. You're just doing fantastic.
That's extremely kind, and I really appreciate it. Happy Hanukkah. Thank you very much.
Yeah. Thanks, my friend. Thanks, Chris. And thanks to you at home for joining us this hour. Losing is one thing. That's bad enough, right? But losing like this ought to leave a mark for a long time. I don't know if it will, but it ought to. Now, whether or not you consider this decision tonight to be a 7-2 decision or a 9-0 decision, the bottom line is that the conservative-dominated United States Supreme Court tonight slammed the door shut on the historic and unnerving effort by the sitting president and a significant proportion of his political party to have the court throw out the results of the presidential election, to have the court throw out the votes of the states that carried the president's challenger over the top to a victory in that election, to instead keep President Donald Trump in power. Now, on the face of it, as we have been talking about it since this Supreme Court case was filed, This challenge that was brought to the Supreme Court by the Texas Attorney General and then joined by so much of the Republican establishment, on its face, it was ridiculous. The case cited no proven instances of anything actually being wrong with the election in any of these states that found their election results under attack. There was no factual assertion that there was anything wrong in any of those states that should occasion the court taking this radical remedy of effectively throwing out the results of the presidential vote in 4 states. The complaint instead cited a made-up statistical analysis that asserted that somehow the statistical chances of Joe Biden winning this presidential election was, I quote from the complaint, less than 1 in a quadrillion. Well, you know, if you think about it, 1 in a quadrillion would be a very small chance. But less than 1 in a quadrillion? Well, that's really something. How did you arrive at that? At one point, the complaint said it was actually even less than 1 in a quadrillion. At least I think this is less. The complaint at one point says there was a 1 in many more quadrillions chance that Biden won this election the way the lamestream media says he won it. And all those lame states, those terrible states, they're all part of the plot, the conspiracy. Well, the plot, the conspiracy apparently also, as of tonight, includes the 3 Supreme Court justices who Donald Trump himself put on the United States Supreme Court. They're all in on it. They're part of the conspiracy. Neither Neil Gorsuch nor Brett Kavanaugh nor Amy Coney Barrett voted that this case challenging the election results should even be heard by the Supreme Court, let alone decided in Trump's favor. When I mentioned a moment ago that the vote was either unanimous, it was either 9-0 or was a 7-2 vote, depending on how you look at it. Here's what I mean by that. What I'm showing on the screen here is the actual order from the Supreme Court tonight, slamming the door shut on this Republican effort to overturn the election. And you can see in the ruling, it's less than 1 page. You can see that Justices Sam Alito and Clarence Thomas set themselves apart from the other 7 justices here. They did that basically, I'm not a lawyer, but as I understand it, they did that basically because Samuel Alito and Clarence Thomas have this long-standing, already stated view that when states sue each other, the Supreme Court of the United States has to hear those cases. The court doesn't have a choice. So Alito and Thomas are saying, in general, we think the Supreme Court has its hand forced here. We think we have to agree to hear any case like this that comes before us. So Alito and Thomas say here, in this part of the order, that they would argue that the Supreme Court should actually hear the case. There should be arguments on the case. It should be argued in full in front of the court. Not necessarily because of the merits of the case, but just because they think that the Supreme Court structurally has no choice but to say yes and hear a case of this type whenever states sue each other. So if you hear people describing this ruling tonight as a 7-2 ruling, that's what they're talking about. Samuel Alito, writing for himself and Clarence Thomas, those 2 justices say they would actually want to hear the case. They would actually want oral arguments and further briefing on the case. But then look at what else they say. Again, the ruling from all the other judges, and the other justices and Alito and Thomas is less than a page. And look at this part from Alito and Thomas. Alito says, quote, "I would therefore grant the motion to file the bill of complaint," which means I would say we should hear the case. But, he says, "I would not grant other relief. I express no view on any other issue." I would not grant other relief. What that means is that Samuel Alito is saying here, yeah, Justice Thomas and I think that we should have heard this case here at the Supreme Court, but we wouldn't have voted to do anything else that the plaintiffs here are asking for. We would not grant other relief. And that's kind of the important bit. That's why some people are describing this not as a 7-2 ruling, but actually a unanimous 9-0 ruling from the Supreme Court. Because what President Trump and the indicted Texas Attorney General and 17 other Republican-controlled states and 2/3 of the elected Republican members of Congress in the House, what all of them were actually asking the court to do, the relief they were actually asking for from the court, was that they wanted the Supreme Court to issue an injunction blocking these 4 states that voted for Biden from actually casting their electoral votes on Monday when all the states cast their electoral votes. That is the relief they were asking for. They wanted an injunction. And the answer from 7 of the 9 justices was, get out of here. We're not even hearing this nonsense. You don't even have standing to sue on these grounds. Alito and Thomas disagreed with that. But when it comes to the meat of the matter here, whether the court would take action to block the states being sued here from casting their electoral votes on Monday, all of the justices were in unanimous agreement with that. No way. 9-0 on that point, unanimously. The court rejected President Trump and the Republicans' effort to monkey wrench the Electoral College process to stop Joe Biden from being elected when the Electoral College votes are cast on Monday. The Electoral College meets on Monday. All 50 states in the District of Columbia, the electors will meet in state capitals and Secretary of State's offices. In some cases, they'll meet in governor's offices. And in each of the 50 states and in D.C., those electors will formally cast their electoral votes. And those electoral votes will be formally conveyed to Congress. And now we know that the United States Supreme Court will not stop them, will not stop that process. And it was a unanimous call. And that marks both what ought to be the final legal defeat for this anti-democratic effort to have the courts override the election and reinstall Trump. It also, of course, marks the 1/4,000th lawsuit on this subject that the president and the Republicans have lost now in a row. I'm rounding up to the nearest quadrillion here, but I'm sort of close. That said, is this over? I mean, from their perspective, effectively this is over, right? Joe Biden is going to get the electoral votes that are going to be cast on Monday. He's going to get enough to declare him president of the United States. They will be formally counted on January 6th. He will be sworn in on January 20th. That will all happen. What are the Republicans going to keep doing on Earth 2? I mean, the president and the Republican Party have raised on the order of $250 million from their supporters just since the election, thumping this idea that somehow if enough, old people and people on fixed incomes give enough recurring donations to Donald Trump, somehow that will make it so Joe Biden didn't just beat Trump handily and make Trump a one-term president. Somehow, just give more money. Just sign up. So maybe, it's not just that Trump can never concede that he lost his reelection effort. It may very well be that the whole Republican Party can never concede that they're going to stop trying to override the election to keep Trump in power. They may need to keep up this impression that they're fighting to do something that will eventually make Joe Biden not the next president, just so they can keep taking money from people. Just tonight, they started running a new ad demanding that Americans give more money, and call their state legislators to somehow make this election not have happened. They started running this now. But the Supreme Court is not going to help with this fantasy, it turns out. Even with 3 Trump-appointed justices on the 9-member Supreme Court, 3 Trump-appointed justices plus Alito, plus Thomas, plus Roberts, it doesn't matter. The Supreme Court is not going to help here. Tomorrow is the 20-year anniversary of the Supreme Court ruling in Bush v. Gore. That was December 12th, 2000, when a bare majority of 5 conservative justices ruled on a narrow issue involving a recount of several hundred votes in Florida, a ruling that those justices insisted would cast no shadow. They said that ruling should never be cited as precedent, as they handed the presidency to Republican George W. Bush instead of Democrat Al Gore. Today, actually, is the 20th anniversary of the arguments being made before the court in that case. Tomorrow is the 20-year anniversary of the ruling in Bush v. Gore. But as bad as that ruling, Bush v. Gore, was for the country, we now know, as of tonight, it will not get a bookend these 20 years down the road, from Bush v. Gore to Trump versus democracy. Joining us now is Mark Elias. He's founder of Democracy Docket. He's a veteran Democratic voting rights attorney. He has played a key role in the Biden campaign's legal effort to fight these bogus election challenges, and he has been very busy. He's litigated over 60 post-election cases thus far. Mr. Elias, thank you so much for making time tonight. I know you're probably exhausted. I appreciate you being here.
I am exhausted, but like all of us, I'm also breathing a huge sigh of relief. Not that this was ever in doubt, but it's good to have it behind us. And Rachel, thank you for everything you've done to keep shining a light on this.
Oh, well, let me ask you about how the quality of the light here, because I am not a lawyer, and I do know that what happened tonight at the Supreme Court, I've seen people who are lawyers and who are very good at this sort of summarizing it in different ways. Let me just give you a chance to tell me if I said any of that wrong, or if you think there's an easier or better way to explain what this court ruling was tonight and how it went down.
Yeah, I think you got it right. I mean, I think the takeaway is that the Supreme Court ruled 9-0 against the president and against the state of Texas, which was doing his bidding here. 7 of the justices said you don't get in the courthouse door. 2 of the justices say, as a matter of rule, we think any state always gets in the door, gets the ability to file gets to file a lawsuit of this kind. But we wouldn't grant your motion for expedited treatment. We wouldn't grant your motion for an injunction. We wouldn't grant your motion for an administrative stay. So even if this case got in the door, we wouldn't do anything to advance it any further. So to me, it's a clear 9-0 result.
And Mark, do you think that this is just the first of a whole bunch of cases that they will figure out ways to get to the Supreme Court? There will be more. Obviously, there was the Pennsylvania case just a few days ago that the Supreme Court also held the door shut on. I don't think anybody thinks there's been any substantive case in any jurisdiction, in any court, anywhere in the country that's going to get to the Supreme Court because the court's going to have a hard time on the merits. But do you think they are going to try to get, an Arizona case or some other case, as many cases as they can, to keep coming up before the courts just sort of indefinitely?
Yeah, I mean, just in the last 24 hours, we've seen the Arizona contest case. This was a case in state court that was filed to contest the election that the Trump's team lost at the trial court, then lost in the Arizona Supreme Court. By the way, the Arizona Supreme Court, not known for its liberal bent, and that they have now fashioned an appeal to the U.S. Supreme Court that they filed today. And the Kraken conspiracy case out of Georgia, I saw they had filed in the Supreme Court. But look, typically filing a lawsuit is just a matter of a filing fee. In the Supreme Court, it's even less than that. So they can file these cases, but they're not going anywhere. And I think after today, even though many of us predicted that this case wasn't going anywhere, I think it's fair to say that Sidney Powell's Kraken conspiracy nonsense is not going to occupy much time at the Supreme Court.
Mark, it is remarkable to have seen you and your colleagues basically win 60 straight here. It was amazing to see it to be a dozen straight, and then 20, and then 30, and then 40, and it just keeps going. They've just lost at every level, and in some cases been really quite chastised by judges hearing these cases about how bad they are and how pointless they are. They've had no traction whatsoever. And I have to ask you now, at this sort of landmark moment with the court having made this decision tonight, if this is more than just wins and losses, if you think the volume and the pace and the unrelenting nature of what they're doing, despite consistent rejection, says something about our democratic process and the two parties that's different than who we might have thought we were coming into this.
Yeah, it's a really good question, and it is the thing that troubles me most about where we are. I was asked a few days ago how many lawsuits are there typically filed by a candidate or by a campaign after they lose an election. And I said, the answer is 0. We can't let this seem normal. I mean, the fact is, I was the general counsel for John Kerry, and I was the general counsel for Hillary Clinton. So I've sat in that room with candidates who have lost closer elections than Donald Trump lost here. And you weigh those options. You say, is there something that can be done? But at the end of the day, our system relies on the fact that when candidates lose and it is clear they have lost, that they concede, both for the peaceful transition of power, which is part of it, but also for the continuance of democracy. Part of the democratic system is the norm of accepting election results. And this was not a close election. I mean, I'd love to say that we won 57 lawsuits because me and the other group of lawyers involved were great lawyers. But the fact is we won because Joe Biden and Kamala Harris won virtually landslides in these states. I mean, these were not close elections. And so what I am worried about is that Trumpism has so infected the Republican Party that this is what the Republican Party is. The Republican Party is the party that not only has an attorney general in Texas who may have his own personal reasons to file a frivolous case in the Supreme Court, because maybe he wants a pardon. But the Republican Party is now a party where 18 attorneys general who didn't have to join the nonsense did. And then a party in which over 120 members of Congress who definitely didn't have to join the nonsense did. And so, where does that leave us in a system that relies not just on people's actions in accordance with the strict law, but in accordance with common decency and common sense? And so I think we need to take a step back when this is all over and look at the institutions we have and the rules we have and ask ourselves, is our current system and rules capable of withstanding the kind of authoritarianism that we saw throughout the Trump administration? But the utter moral bankruptcy and willingness to go along with it by one of the two major national parties.
That is stark and very well put. Mark Elias, founder of the Democracy Docket, veteran Democratic voting rights attorney, has played just a pivotal role in the Democratic and Biden campaign efforts to fight these election challenges. A huge night tonight with this Supreme Court rejection of what the president called the big one. Mark, I hope you can get some rest. I doubt you can anytime soon, but thank you for helping us understand the meaning of this.
Still mopping up, but thank you very much, Rachael. Thanks.
Yeah, thanks. All right. So this is one of those Fridays when we've been...
So let me mention that the Republicans are in power because of the Southern strategy. Please go back and look at that. Also look at Dr. King, Reverend Dr. Martin King Jr.'s speech from March 25th, 1965, the Selma speech, where he mentions in the 19th century blacks and whites were voting together, and then they brought in Jim Crow and segregation and other means to stop these people from voting their own self-interests, both the white Americans and African American Americans. And there's a book called Dog Whistle Politics, How Code of Racial Appeal Has Reinvented Racism, Wrecked the Middle Class, and basically saying that, racism hurts white Americans too. It hurts all of us, everybody. That's by Professor E. Hanny Lopez, and how dog whistle or bullhorns right now have been used to divide people when we're all the same people and we all have the same needs, right? Jobs, housing, food, clothes, all right, all these things. Whether you're a poor white American, a poor African American, a poor Asian, or Latino, Latinx doesn't really matter. We're all human beings, and there's one race, the human race.
Waiting all day and into the night for a bunch of news we were pretty sure was going to be happening. We were not necessarily counting on, but we were expecting tonight's Supreme Court ruling, which, as we've been talking about, absolutely shut down this effort by the president and a huge chunk of the Republican Party to throw out the presidential election.
And today is Friday, December 11th, 2020.
Election results and keep Trump in power, even though he lost the election. As we've just spoken with Mark Elias about, that has now happened. The Supreme Court firmly closing the door to the president on this case that the president had called the big one. This is the one he's been telling his supporters would be the case by which he overthrew the election results. That's not going to happen. We've also been expecting that the president tonight may veto what's called the National Defense Authorization Act. That's the bill that funds the military. The president said he would veto it first because he wanted the military to keep all the names of its bases that honor figures from the Confederacy and the Civil War. So he was going to veto all funding for the military over that. Then he dropped that and said he wanted to veto it instead because he wants to use the military funding bill to go after social media companies for something. Well, both the House and the Senate passed the bill to fund the military anyway, and they both passed it by margins so large they can easily override Trump's veto if he does in fact try it. Now that, of course, will be an embarrassment and a real sign of weakness for the president if and when it happens. So if I were him, I might try to bury that late on a Friday night when there's lots of other news. So we're watching for that tonight in terms of the president's expected veto of the bill that funds the military. We're also, of course, watching for potentially more pardons from the president, right? Late on a Friday night with lots of other news in it. That's a great time to bury any particularly embarrassing pardons. The New York Times today reporting on the speedy advance of a known criminal case against the president's business in New York, an investigation reportedly implicating behavior by not just the president's company, but at least by some of his adult children. And while those are state prosecutors pursuing that criminal case against the Trump Organization, that reporting today in the New York Times about the pace at which that case is now moving, that may sharpen the president's mind about whether it's time to start issuing preemptive federal pardons for his family members, for his kids, for his associates. But also, of course, we've been waiting all day on potential news from the FDA. After the group that advises the FDA on the safety and efficacy of vaccines, they last night voted that the FDA should approve the first coronavirus vaccine in the United States. We have been waiting today to see whether the FDA would respond to that by, in fact, approving the vaccine. Just in the past few minutes, that has just happened. The New York Times breaking the news that the FDA has just approved the Pfizer coronavirus vaccine tonight. We will have more details coming up on that in just a moment with somebody who is very much in a position to understand exactly what that means. Plus, we'll be talking about the fact that the Trump White House really does appear to have fundamentally screwed up even that good news tonight at the very last minute with a very ill-timed, very ill-advised threat against the FDA. We've got all that coming up. It's a big night, and I think it's probably going to keep getting bigger as the hour goes on. Stay with us.